Way.
All right. So without further ado, we're going to kind of get into the slides. Again, my name is Spencer Baxter. I'm an attorney with Johnson, Gasink Baxter. Some of you may recognize me. I've taught some of the classes with David in the past, well, the estate planning side of things. But today we're going to cover the basics of estate planning, some of the changes in the law that have impacted current plans, just a general good review for you if you have a current plan in place, as well as some of the things that you can look if you haven't updated things in the last couple of years. I'll cover at the end, assuming we have time and so forth, some of the potential changes that could be coming down from the new administration with the election of Joe Biden. So, make sure, there we go. All right, when we talk about an estate plan, there's going to be a couple different components of a well-rounded estate plan. Really, the gist of it is going to be making death decisions, or better stated, who you want to receive your assets, but it's also going to be important to identify who you want to make financial healthcare decisions at your incapacity. The combination of the two of these types, or these two of these facets of an estate plan is going to make a well-rounded estate plan. All too many people focus on, I just need to have a will because that's who says who gets my stuff when I'm gone. But with that in place, that's going to take care of the distribution of your assets, but it's not going to name somebody if and when you become incapacitated. So let's kind of take a step further through that. So some of the disability plans that are the most common would be, probably with a will plan to begin with, would be doing nothing. So if you just had a will in place and you had nothing else, no durable power of attorney, no trust in place, then the problem is you have not identified somebody to make decisions on your behalf. That becomes problematic when obviously you can't sign, you can't direct somebody to do something for you. So the option that your loved ones will have is a court conservatorship. In Virginia and in many other states, a court conservatorship is a court-driven process where someone will have to petition the court in order to become your decision maker to make financial decisions, investments, different things of that nature that they will be making decisions on: paying your bills, keeping lights on, paying for your care if you're in a long-term care facility, whatever it may be. Not to mention the cost is anywhere between $3,000 to $5,000 in some cases. That's assuming that it's uncontested, meaning you don't have different family members trying to all qualify for the same thing. And then you also have an annual accounting that has to go from the person who's appointed as the conservator to the commissioner of accounts. And that's going to be a hassle. It's going to be kind of a headache for the person named as the conservator. Not to mention, it's the court and the commissioner of accounts kind of looking into your own personal business. So the better option is going to be to create a durable financial power of attorney. That document is going to identify who you want to make decisions, not let the court decide for you, but who you, in fact, want to make decisions. And then it's going to also identify the authority that they have. So one of the things that we see commonly with a durable power of attorney, the issues that we see are, A, it's too brief. It doesn't give specific authority to your agents. It just says, generally speaking, I give them legal authority, but it doesn't say that they have the ability to refinance a mortgage or change investment vehicles or whatever it may be, take assets out of one financial institution and transfer them to another. So a bigger power of attorney is a better power of attorney in a lot of cases. The other common issue that we see with a durable financial power of attorney is the issue of time or durability of that document. When a power of attorney is created, it says that it's good forever until you pass away. The problem is whether some financial institution or some individual is willing to accept that power of attorney the longer that power of attorney has existed. So our rule of thumb is we recommend updating financial powers of attorney about every 5 years. In doing so, your agents can stay on top of things. Obviously, there's changes in the law that could impact things as well. But by having an up-to-date power of attorney, as well as a robust power of attorney, in most situations, they're going to be a very viable document to use or an alternative versus going through a court conservatorship. Now, the next kind of power of attorney that comes in play is going to be a healthcare power of attorney. This is a common document. Most of us are familiar with this. This is going to be the document that identifies who you trust to make medical decisions if you can't make them for yourself. i.e. you're unconscious, you don't have the cognitive ability to make decisions, or you're in the middle of a surgery and somebody needs to tell the doctor, yes, do this, don't do that. So a healthcare power of attorney is very important, and that document also needs to have a HIPAA release. That stands for the Health Insurance Portability and Accountability Act. That provision gives the authority to the hospital to communicate your condition to your agent and for them to communicate openly. Without a HIPAA release, the hospital cannot disclose your medical information, which obviously presents problems for somebody making those decisions on your behalf. A document that accompanies your healthcare power of attorney is going to be the living will. That's going to be the document that identifies at your death or before your death, and when you are terminal and irreversible, whether you would like to be artificially prolonged, IV fluids, ventilators, things of that nature. Most of us don't want to be artificially prolonged if there's nothing that can be done to really bring us back. So that's what most of those documents say. They also give the authority to the person named under your healthcare power of attorney as your agent to ultimately make that decision and correspond and discuss this with your physician. The difference between a living will and a do not resuscitate is a living will says this agent can make these decisions on my behalf. A do not resuscitate says don't touch me to begin with. So a DNR is a hard and fast rule that says don't defibrillate me, don't give me CPR, don't do any of these extraordinary measures because I don't want to be prolonged. Most of us do not want nor need a DNR right now, but we have that when we are in a terminal and irreversible situation. We have a terminal diagnosis of cancer. We don't want to be defibrillated. That's when a DNR is put in place. So if we have, well, next step that we need to talk about is who receives our assets when we're gone and what kind of planning can we put in place to identify that. First option is not one that I typically recommend, which is do nothing. And that's where the default laws of intestacy will control who is your beneficiary. Most people say, it's okay, I'm married, therefore I don't need to create any kind of plan because it's all going to go to my spouse. Unfortunately, that's not always the case because under the law of Virginia and in many other states, if you have children from a previous relationship, not of that relationship with your current spouse, and you pass away, in many instances, assets will go to the children. In a large majority will go to the children and a small amount will go to the surviving spouse. That's not always what people want, but that's exactly what can happen in certain situations if no plan is put in place, i.e. you don't have a will, you don't have designations, okay? So obviously the better choice is, instead of relying on the default laws of intestacy, is to create a document that says who you want to receive your assets. The most common document is a last will and testament. This is going to identify who you want to receive your assets. Now, in my case, I have 2 young children. Suffice it to say, I don't want them to make their own financial decisions for a long time if my wife and I pass away, or when my wife and I pass away. So I need to be aware of my children that are under the age of 10, that they shouldn't be making financial decisions for a long period of time. So what that right age is, that depends on personal decisions. My documents, I have a trust actually that says my kids can't make their decisions until they're in their 30s, just because I feel that's probably going to be the right age for them. But again, I don't know who they are because they're so young. That's a decision that really kind of comes down in the discussion with your estate planning attorney of what's the right age, what's the right circumstances. But a will is going to be great at getting money to the right people, not controlling it. So if I had adult, responsible children, maybe a will would be the right decision because I'm not concerned about their ability to make decisions. One of the other things that people have a lot of concern about is those son-in-laws or daughter-in-laws that they don't necessarily like very much. And what happens if assets are passed down and a divorce occurs? The safest thing to do is to pass assets in trust, which can shelter and protect those assets and not make them a marital asset. Most people, when they receive inheritance, will commingle those assets with a spouse, and then they could be lost in a divorce scenario. Or in a most tragic of situations, if the beneficiary is receiving Medicaid or SSI, if we leave money directly to that beneficiary through a will or even beneficiary designations like from your IRA or life insurance, it will likely disqualify them from their government benefits, meaning they were receiving the benefits, they have this money that they receive, which is a blessing, but then they have to spend down the money that they've received in order to qualify again for Medicaid or what other benefits they're receiving. The threshold for Medicaid in Virginia is about $2,000, meaning you cannot have more than $2,000 of accountable resources in order to continue receiving those benefits. A will is also going to name who should be the physical guardian of any minor beneficiaries. So in the world of estate planning, you have who has physical control of a minor and who is in charge of the money. With a will, you're pretty much giving the money to them once they hit the age of 18 when they're an adult. But then up until that point, you need to name who's taking care of them, who's making sure they go to school, who's making sure they're fed. That's going to be the guardian. Now, the will directs your wishes, but ultimately the court will make those decisions to verify that the person you've named is indeed fit to be your guardian. The will also identifies the executor, who's going to be responsible for going through probate. And probate in Virginia, we'll get into that in a second. But the key to think about is that if that person is not a Virginia resident who you name as an executor, they'll probably have to be bonded with surety, which is an additional expense and anywhere between $1,000 to $2,000 a year, as long as they're named as the active executor, just because they are not deemed as suitable as a Virginia resident. That's just the rules as things are kind of set up in Virginia. So the probate process is really there to take assets out of your name and put them into the name of beneficiaries. That starts with somebody initially qualifying with the clerk of the circuit court. In doing so, they take the will. If there's a will, or if there's no will, then they would go and qualify under the laws of intestacy and the hierarchy established under the Code of Virginia on who can qualify first. Once they've qualified, they receive paperwork that gives them certain authority to change titling of the assets and start making distributions potentially. Within 4 months of qualification, they have to submit an inventory, which is listing the day-to-day value of the assets. Within 16 months of qualification, they have to submit an accounting. The accounting is going to be the biggest workload because you have to document all of the assets that are started in the estate, how they've been distributed, any income that's come in, any bills that have been paid out, until you have a balance of 0.00. If you don't have a balance out, everything balancing out, you haven't documented everything with canceled checks, account statements, then the Commissioner of Accounts is not going to let you close out the estate. Typically speaking, the cost for probate is between 3 and 5% of the estate value. And the timeline for this is usually between 9 months and 2 years. Usually nothing less than a year to finalize probate. Now, that doesn't mean your beneficiaries are not receiving assets by the time probate is closed out, or they don't have to wait until the end of probate to receive their assets. They can receive it during this process. But the executor who you name is going to be going through this paperwork in the meantime. Again, I don't like to do complex math, so we can look at the simple numbers here. If you have an $800,000 estate and if you have those assets going through probate, which is a combination of court fees and taxes, as well as attorney's fees and accounting fees in some cases, as far as hiring an accountant, you can look anywhere between $24,000 to $40,000 for an $800,000 estate. No, that's not money that you personally are having to shell out, but that's money that's not going to your loved ones or your children. That's a question that you have to ask yourself of what's going to be the best decision for you and for your family. The executor fees are not necessarily part of this overall evaluation. They kind of do come into this a little bit, but the Commissioner of Accounts recommended fee schedule says that your executor is perfectly within their rights to take 5% of the first $400,000, 4% of the next $300,000, 3% of the next $300,000, and you can see where it goes from there. So on a $1 million estate, you'd be looking at executor fees at the tune of about $41,000. None of this is going to be counted as a distribution if the executor is also a beneficiary. So this would actually count as taxable income to that beneficiary if they were also acting and being paid as the executor. Taxation to beneficiaries just depends on the type of assets and the type of plan that you're creating, which is probably a little too complex of a conversation to have for today. But you can see that there are expenses associated with probate that are not always the best thing. But the good news is wills are typically construed as less expensive upfront to create or for you to pay to create them, but they're more expensive and more burdensome and arduous on the back end. You can use beneficiary designations, which is something that I know David and his team work with their clients a lot on when I work with clients, we give specific designations on how to make sure their will or their trust plan works. But these are not to be taken lightly because each one of these little designations are their own little mini estate plan. So if we have life insurance or IRAs or 401ks, we can name a person or an entity as a beneficiary. And the nice thing is that it will pass to them in most cases outside of probate. The downside is that if you mess things up, you don't have a beneficiary, or you put my estate as the beneficiary, then you're looking at running those assets directly through the probate process, which obviously is not going to be as efficient and can have significant costs when you start looking at those things. So the key to success is be vigilant with your beneficiary designations. In some situations, I've seen clients who had their spouse named, they didn't update it to have their children named. Both spouses end up passing away. There's no residuary beneficiary named, which means all of that money has to go through probate in order to pass down to the kids. There are efficient ways to take care of things. It's just a matter of doing them before you are incapacitated and before you're deceased. So another option that you have are revocable living trusts. Now, the concept of a trust is new to some people, or you may be very familiar with it if you have one yourself. A trust is very different from a will because a trust is going to allow for assets to be put into the trust, and then the trustees of that trust control it. So in this situation, you as the creator of the trust would be the trustee. In a lot of cases, this would also use your Social Security number for tax ID. So it doesn't really help or hinder your taxes. It's pretty much neutral as far as treatment of your taxes. Additional things, if you are married, if the first of you passes away, assets can be left in trust for the benefit of the surviving spouse. Or if you have a blended family dynamic where you may have different children, you want to provide for each other, you can actually set it up so that assets are left in trust for the surviving spouse, but at their death, they revert back to your children who you've identified, as opposed to the surviving spouse leaving it to their children. Think of the Brady Bunch type scenario. So trusts are much better at taking care of the complexities that come with blended families, not to mention having your assets in trust at the first death of the first spouse, at the second death, avoids probate in its entirety. We've avoided that 3 to 5% cost. We've also avoided the 9-month to 2-year timeline that we typically run into. Typical trust administration is wrapped up in a couple months. It can take longer. That's usually just a variable that depends on the type of assets that are in the estate, as well as how quickly the trustee wants to get paperwork signed and get things wrapped up. Now, the nice thing about a trust is that once you pass your assets down to beneficiaries, you can actually control how they receive it. So I said before that I have a trust and that my children cannot make their own financial decisions until they're in their 30s. Up until that point, I've identified people that can make decisions on their behalf. It has to be for my children's benefit, but at the same time, they don't get to say that I want a new car every 6 months. They could say that, but the trustee doesn't have to give them that money to do so. Not to mention, so I've controlled for financial immaturity. Assets left in trust for their benefit are not going to count as marital assets, which means they're not commingled together, which means if a divorce happens, then it's not going to be a susceptible asset. Not to mention, we also have language in the document that's going to protect those assets if any of these underlying beneficiaries ever became recipients of Medicaid or SSI. It's a sheltered or an invisible asset that will not count against them for their eligibility. Or a better thought of, it's available above and beyond what benefits may be provided by the government, not instead of. Now, if you have a revocable living trust in place, the key to success is making sure your assets are coordinated correctly. If you're a client of my firm, then I gave you very specific instructions on how to fund your trust, how to title accounts. I work with David and his team to make sure that they can help you on any assets that they have control over, to make sure that the beneficiary designations or the titling of the property is correct. If you do not have these correct, we can end up with probate applying to your assets, which is one of the main reasons people create a trust to begin with. So if you're not sure that your trust is properly funded, I would highly recommend that you sit down with your attorney. If it was my firm that helps you out, then just give us a call. Or if you'd like to have consultation to review your plan and to have further guidance given on funding your trust, give us a call as well. So kind of simple way to look at things, wills are less expensive from a cost perspective up front to create them. How much are you going to pay out of pocket to create a will plan? Trusts are more expensive up front. There's more to them. There's more to create those documents. And you have to think of it because a trust is going to avoid all of the court process. We have to create a pretty sophisticated plan to be able to work outside of the parameters of the Commissioner of Accounts and the probate process. Trust administration is less expensive and is quicker than probate administration because we're reliant on the court to work on their timeline. And unfortunately, they don't work on a very quick timeline. It's just the way that it goes. Trusts, on the other hand, is as quick as the trustees want to get things wrapped up. And obviously, we have greater control and protection and privacy without having to run through the court versus the lack of control or just kind of getting on the roller coaster ride of probate that you have to ride it through to the end before everything is complete. So who should be your executor trustee? There's a lot of questions that come up these days. You have attorneys, CPAs, banks, you have family members, you have friends. The real question is, who do you trust with your money? Who do you trust with making these decisions? And I've had plenty of clients that say, well, I don't trust anybody, Spencer. Well, we have to trust somebody. Most people will name family members or friends. And then those family members or friends can consult with attorneys to give them guidance, but the attorney or the bank is not actually acting as the executor or the trustee. So it's usually a little bit more cost effective to do it that way, but you're relying on your loved ones to take on the task of contacting financial institutions, filling out the paperwork, things like that. The other option is you hire an attorney, you hire a CPA, you hire a bank or a trust company to act as your trustee or executor. The problem is there's higher fees associated with that, but there's no obligation or no burden on your family members or children. That's a personal decision that you should discuss with your estate planning attorney. There's no right or wrong answer. It's just what are your family dynamics, what makes the most sense. All right, so Secure Act. This is a law that had an effective date of January 1, 2020. And what this does is essentially changes the treatment of your IRAs when they are passed on to someone other than your spouse. When you leave an IRA to your spouse currently, there's still a spousal rollover, which means your IRA, which means they don't have to start taking withdrawals until they reach that age of minimum distribution. The Secure Act changed that. It used to be 70 and a half, and now it's 72. So it bumped it up a little bit. But the real thing that the real impact with the Secure Act is that when you have a beneficiary, if they're under the age of 18, then they have to start taking RMDs based on their age. So they have to start taking incremental amounts that has to be distributed directly cash in hand to them every year. And then once they reach the age of 18, then they have 10 years that all of the money has to be withdrawn out of that IRA, i.e. it all has to be cashed out and distributed to them. And then that all counts as income to them, which unfortunately IRAs condensed in a very narrow timeline will usually result in higher income tax treatment because you have larger amounts in a smaller tax year. Not to mention, we don't have the ability as well to control and protect that. I don't know about you, but 18 is a pretty scary age to say maybe 10% of an IRA has to be distributed to an 18-year-old. Suffice it to say, they may not make good decisions with it. So there are ways to secure this money for longer. If you have a current trust in place, your trust is probably going to have an amendment done to that. My firm reached out to pretty much all of our clients and friends of the firm to let them know that there are updates that should be put in their trust documents for the Secure Act to update for this. But what it does is, instead of forcing it out in that 10-year period, the trustee has the authority to retain it in the trust for longer periods of time. This would be important for somebody who's a special needs beneficiary or somebody that's just not a good financial decision maker, to allow for a longer timeline for use of that funds and not pile it all on them in one big thing. So some of the things that you can talk about with your financial advisors, or talk with David and his team, Roth conversions are a good option that a lot of people are looking at these days, that can help minimize some of these issues with stretching of IRAs as far as tax treatment and adverse tax treatment. But at the end of the day, you need to talk to your financial advisor. You need to talk to your estate planning attorney on how the Secure Act impacts your estate plan and whether or not you need to make changes to your plan. These are some of just the tax rates that you could look at as far as if you have to retain assets in trust. I'm not going to get into too much of the details of this today, but there's different avenues that we can take to minimize taxes for beneficiaries and for your trust. So right now, we're kind of at a precipice where we have, what most scholars would say, we have a president-elect. There obviously are some pending court cases going on. Current President Trump has put forth some court cases for the interpretation of different voting and whether there was voter tampering or whatever there is. Most people are leaning towards the fact that we do have a president-elect that will take over in January. So really what the question is with a new administration, what kind of laws are we likely to look at in the future? So Politics 101, with Republican control, we typically have high exemptions, meaning a coupon of sorts that exempts your estate from estate taxes, and we have low tax rates. Also, the same thing typically applies on income taxes. So typically lower income tax rates, higher exemptions. When we have Democrats in control, typically we have higher tax rates and lower exemptions. That is really kind of holding true. Some of the platform that President-elect Biden has taken is aiming at changing some pretty significant parts of the tax code. The first of which is to take the current federal exemption, which is, again, think of it as a coupon for your estate of $11.8 million, and reducing that back to 2009 numbers of $3.5 million. So that's a pretty hefty shift backwards. I don't know if it's going to get passed. This is all things that are going to have to play out as the next 6 months kind of plays in. I know it's going to be probably pretty interesting 6 months between pandemic, vaccine, and potential change of the presidency and change of tax laws. But so the reduction of the estate tax exemption is one of the things that is part of his tax platform. So that would essentially say if you are an individual and you have $3.5 million, the effective tax rate above that would be about 45%. So anything above $3.5 million would start to be taxed pretty heavily, pretty quickly. This becomes a big issue if you have a liquidity issue, i.e. all of your property is tied up in a farm or tied up in a business. That can be pretty problematic because those taxes are typically due within 9 months of your death. These are things that can be structured and planned around. You just need to take steps today versus in the future. If you haven't done anything when you pass away, there's really no planning at all. The other thing that we look at is the change in capital gains treatment. So the current law says that if somebody buys a piece of property for $200,000 and when they die, it's worth $500,000, the new basis for the person that's inheriting that property is $500,000, meaning they sell it for $500,000. It was worth $500,000 when the original owner died. There's no capital gains that are going to be taxes that are going to have to be paid. There's new provisions that are potential under the Biden tax plan that would say there would be no step up to that date of death value. Essentially, it would be either a deemed sale or it would be a transfer at the original owner's basis for the inheriting person. Either way that you play it, you're talking about significant capital gains. This is kind of a 1-2 punch because the plan that also says anybody that has capital gains income or just income in general in excess of $1 million would also be taxed at the top effective ordinary income rate of 39.6%. If you also add in a net investment income tax, you're talking about another couple percent on top of that. So you're potentially talking a capital gains tax of about 40-some%, which could be pretty significant. Current tax rates for capital gains range as far as your income. It could be anywhere between 0, 15% threshold, and then there's a 20% threshold. So we're talking about potentially a 19, 20+% uptick in capital gains taxes at the death of of an individual. So these are kind of a 1-2 punch that could have a significant impact. We don't know what's going to happen. So you have to just kind of stay tuned on things. If you have interest in this, you can contact my firm. We have a newsletter that we put out monthly that's going to be talking about these changes in the future. If you have questions that I haven't answered, or if you have some interest in setting up an appointment to have your documents reviewed or anything of that nature, you can reach out to me. You can reach out to David. I'd be more than happy to have a conversation with you. It's a complimentary consultation. We do it over Zoom these days to begin with, just to be safe. And I think that's about it. David, do we have any questions that have come in?
Got backwards from 10 minutes ago.
All right.
So 10 starts now.
All right. Yes, we do have some questions already. I'm waiting for Caleb to put me back live here, but one question that came in, Spencer, is that if someone that says my trust was done about 3 years ago, do I need to do anything now to fix it based on the new laws?
So the Secure Act, my firm, if you're an existing client of our firm, we've reached out to you in a variety of different ways, email, letters, and so forth. And if we haven't somehow missed you and you fell through the gaps, there is an amendment to our document that needs to be done to update for the Secure Act. So if you have a document from about 3 years ago, I would recommend contacting our office, or if you worked with another attorney, talk to that attorney. Obviously, I'd love to work with you, but contact the attorney that you want to work with for getting an update on those documents. And it's at least worth a conversation. Technically speaking, if you don't have any IRAs, 401ks, 403bs, TSPs, it's not a big issue because the Secure Act only really impacts those type of qualified accounts. But the short answer is, yes, there's an update that should go in your documents. Good question.
And I just want to remind everyone, too, that you can email me right now live at team@rvawm.com if you have some questions. So we've had a couple come in. But feel free to send them in. We can stay on and we'll do our best to answer them all. I had one which says, Spencer, I have a will that's been done. It looks like. Do they need anything else? I think they said something about power of attorney or something. So I think they're wondering. I think maybe they have a will, but maybe they don't have the rest of the documents. That's what it sounds like.
Sure, that's a pretty common thing. Typical when you go and talk with a general practice attorney. Because most people say, I need a will. It's this concept that we have in our mind that I need to have a will. It's the responsible adult thing to do. But at the same time, the will only takes care of distributing your assets when you're deceased. It doesn't take care of naming somebody who's going to make medical decisions or somebody who's going to make financial decisions at your behalf when you're incapacitated. And I hate to be the bearer of bad news. There's a really good chance we're all going to die. That chance is almost as good that we're going to be incapacitated at some point. So having a plan that takes care of both of those sides of things is really the best thing for you.
All right, well, thanks. Here's a good one for you, Caleb.
You can also contact us and I can send these slides out as well.
Good. And here's a good one, Spencer. It says, how much does it cost? I don't know. I don't know. It's just the question is, how much does it cost?
That's a good. So the initial consultation with my firm is complimentary. So if you are not a client of the firm, there's no cost to have a consultation. And then everything that I do is based on a flat fee. So we would discuss what those fees would be depending upon what estate plan you wanted to put in place. If you have an existing plan, then there could be a doc review fee, and the fee for that doc review is credited towards the work that you would be doing to update. So best thing to do is give us a call. The way my firm works is that there's never any fees unless we've told you about them beforehand. I have clients that call me 5 years later, and I don't actually charge for telephone calls in those circumstances unless we indicate otherwise, unless there's work that needs to be done that's going to be chargeable. But 99% of the time, there's no hourly rates for any kind of the work that we do either. Good question.
Yeah.
Her answer is
I had another one come in and probably this is from the the stuff you were talking about there at the end. They said, my estate is over 3.5 million. What do I need to do to prepare if it's, I guess what they're saying is if it goes to the 3.5, if the estate tax thing happens and it drops down to 3.5 million, what can they do about that?
There are other options that are available, and it really needs to be given consideration. If you're married, there's certain things that you can put in place as far as making sure that both you and your spouse's federal exemptions are being claimed. If the plan is not set up correctly, then you may be missing out on the first spouse's coupon. So that's one thing to keep in mind. But there is upper level planning that can be put in place. Irrevocable life insurance trusts, grantor retained annuity trusts, charitable remainder trusts, qualified personal residence trusts, all these fun acronyms, CUPERTs, ILETs, GRATs, GRITs, all these fun acronyms that lawyers like to talk about, but aren't really that necessary in today's environment where the exemption is $11.58 million per person. Most people don't have a tax problem.
Right.
But if that number back down to $3.5 million per person, that's a number that gets very close to a lot more people. So there are steps that can be taken today, but it really would involve a conversation of what are your wishes? Talking about a charitable remainder trust, the key term is charity. So if you have no charitable intent, that's probably not going to be a very good choice for you. But if you are charitably inclined, there's other avenues that you can take with this. If you have a business, we talk about family limited partnerships. These are things that we can start utilizing, and we can only plan so much on speculation of the law because we may get caught in a situation where the law doesn't pass. This is just what the platform of a president-elect is. That doesn't mean it's going to get passed, but it is something that we need to be very aware of in the coming months, just to kind of look at things. I mean, just this morning I was reading an article. One of the things for the platform for President-elect Biden was reduction of student loans. And just this morning, he's already talked about further detail of what he wants to put in place for the reduction of student loans. Asked me the actual details of that plan, but he wants to get rid of or reduce student loan debt. That's just one of the things that he's kind of campaigned on. So.
Yeah, so what you're saying is we really don't know what it's going to look like at this point. We only know what's been proposed. And of course, in Washington, they call it making sausage when they do legislation and push things through, especially related to the tax code. And you never know what's going to come out on the other end. So it's just what can they get passed is really the bottom line. So go ahead.
It's going to be an interesting situation because if you look at the relationship between Mitch McConnell and Biden, they have a good working relationship from the past. And there's some argument of whether that's going to continue or not. So things are up in the air. I mean, there's pretty much a guarantee that there's going to be attempted change. That's a guarantee. There's going to be attempted change. And there's enough pork that can get attached to it from one side versus the other to get it passed. That's another question. That's another issue. If you look at the Secure Act, so really what the Secure Act ended up doing was the Secure Act was a tax grab by the government. Instead of waiting a lifetime for this money to trickle in for income taxes when an IRA was taken out in small increments by a beneficiary, they squeezed it into 10 years. What's really fascinating is that was voted on almost unanimously, Democrat versus Republican. So there was so much voting for it that it didn't really matter which side of the table you were on. Everybody ended up being in agreement with it. So but there was enough things that kind of greased the wheels with enough of the different senators and everybody in Congress that it ended up passing. So nothing should surprise us when you have a motivated president and you have a motivated Congress to get things changed. Like you said, David, you never know what's going to end up coming out.
Right. You just don't know. And it is concerning. And by the way, we do ILETs here, Irrevocable Life Insurance Trust, to take care of some of those estate tax issues. We can help with that process. So if it does come to that, and we're hoping that it doesn't, but hey, there's planning tools available to us if something like that is passed. So
the foundation pretty much for any time you're building on further estate planning needs, the foundation is usually a revocable trust, not a will. And from that foundation of the revocable trust, then you can add on things like an ILIT or a charitable remainder trust or other types of options.
Right. Absolutely. Any more questions? I haven't gotten any more in. So I don't know if you, I mean, I really appreciate the update, Spencer, and the insights on the Secure Act as well as on what may be coming down the road. I understand that there's a wave two, I believe, relative to the Secure Act, where there's going to be additional modifications of raising of the RMD up to age 75, I believe. But I don't know if there's anything else in there that's going to impact estate taxes negatively. I'm not real sure about the added things that are coming up. So, but I do know that there's some things that might be coming. So I don't think it's been passed yet, but it's been floated around.
Always fun little things. It's like back in 2010 when the estate tax exemption was bumped up to $5 million. And in 2017, we went from $5 million to 11.5 with an inflation rider. You know, these changes kind of come out of left field in some cases. But the Secure Act was flying kind of under the radar for about 9-10 months before it was actually passed. We were monitoring it, but it never gained the momentum until the end of last year. And then all of a sudden, everybody was behind it, and it was go time.
Yeah, we'll see. I mean, it's just like I said, we don't know what's coming, but we need to be prepared, and there are options. I think that's the good news. We've got options for addressing anything that may come down the pipe. Really, we've probably seen it before.
Absolutely. So, well, thank you, David. I appreciate it, and hope this was helpful for everybody. And I think that's about it.
All righty, Spencer. Thank you. Appreciate it. And we'll be in touch.
All right.
All right. Take care, everyone. Thank you again for attending. We appreciate it.